think either side has any disagreement as to the second sentence in 7.54, that the ballots are to be opened during an open session, and that, that they must be viewed in front of the person that has custody of them. As for the first sentence in 7.54, I also think that myself and the respondents agree on a lot of it, which is that this is a contested election, that these are contesting parties, and that they have a right to have the ballots opened and to have errors corrected. Where we begin to diverge is when it gets on to its application to the Board of Canvassers or court.
The word "or" is something that interests me. So,
yes, Chief Justice Ziegler, we think that the word "or" in this, through the context, is fairly clear that it's the inclusive use of the "or." That is, according to the Wisconsin Drafting Manual, the default meaning, unless the context is very clear otherwise.
And then they added the sentences that said in all contested elections, contesting parties have the right to have all ballots opened and any errors of the inspectors in counting or not counting corrected. And that always had to be done either in open court or in open session of the board. And the reason for the "or" language in 1905 is there were two alternative methods to do it. And so the statute simply directed that if you're in front of a board of canvassers, it's the board of canvassers that corrects those errors, and they have to do it in open session. If you go quo warranto, or you're suing under the provision at the time that allowed you to go to court on allegations of illegality, it would be the court doing that. And that's how the case law from back in the early 1900s indicates. When it was a quo warranto action in the circuit court did the recount. Whatever was necessary to correct errors, including recounting ballots, circuit court did it. When you went before a board of canvassers, the board of canvassers did it. And Wigan, the case they cite to support them, actually supports the exact opposite.